Hi, good afternoon. Welcome to SCOTUS Blog's seminar about Our Lady of Guadalupe School versus Morrissey-Berru and St. James School versus Beale, the case the Supreme Court heard oral argument on earlier this week about the ministerial exception and its application to teachers at religious schools. With me today is Dan Mach, I'm sorry, of the ACLU, and I am Kevin Russell from Goldstein and Russell. We would invite folks to go ahead and send us questions about the argument. We are, as in our preview, going to be focusing on directing this as a discussion for high school students, and we hope that this will be informative for the students, not only about this case, but also we'll try to talk a little bit about the Supreme Court in general and oral arguments at the Supreme Court. But to get us started, maybe Dan, you can just give us a general idea about what about the argument surprised you or was most notable to you?
I think the entire argument was premised on a potential clash between two important competing values that we as a society have embraced. And on the one hand, we have the rights of religious institutions, the constitutional rights to select their ministers, to select who should lead the faith institution and who should spread its religious message. And on the other hand, we have the important anti-discrimination rights of employees. That is to say, the right of people not to be discriminated against on the basis of various protected characteristics: disability, age, race, sex, religion, etc. And so I think that was one of the themes that animated this entire argument, was how do we balance those interests? And the Supreme Court has said in the past, as we've talked about, that when it comes to selecting core religious leaders, faith institutions do not have to worry about anti-discrimination laws. And so then the real question in these cases is, how do we determine who is a minister, and how do we ensure that that category of religious leader, we'll call it minister, is big enough to protect the rights of religious institutions, but not so big as to sweep in other employees and allow them to face all sorts of invidious discrimination without any legal recourse.
So there's a lot of hypotheticals during the oral argument, weren't there, where the justices were trying to figure out, what is the right rule? And they're sort of trying to do it backwards, right? They're figuring out sort of as an intuitive level, nobody thinks the janitor should count as a minister. And so if your test says the janitor is a minister, well, the Supreme Court's going to think that's probably not the right test. And so there was a lot of questions from the justices about who would be included or in what circumstances under the tests offered by the two sides. And what did you think about their answers?
Yeah, I think, one of the things that any Supreme Court advocate has to prepare for is these hypotheticals. So the question is not just what happens to the particular litigants in this case, but what rule are we, the Supreme Court, going to lay down for all future cases? And so we have to test your theory. Just because we, the court may think that these particular people count as ministers, what about the next case and the next one after that? And so I think one of the challenges for these folks who are arguing is to come up with what we call a limiting principle. So if you're right, what are the limits of that? And so you have to be ready, as the attorneys for both sides were, you have to be ready to give a little, to concede a little, to say, if you're the attorney for the schools, for example, you have to be able to quickly say, no, a janitor doesn't count. And my rule would not sweep in the janitor. Then there are the tougher questions, the middle fuzzy area, like coaches at religious schools. And the answer to that the school's attorney gave was maybe. For coaches, maybe they're ministers. It depends. It depends on what else they do besides giving a prayer maybe just before games. What about the math teacher who's told to teach about Judaism only 10 minutes a week? Again, the answer there was no. So those were some quick, ready concessions that I think were intended to give the justices who may not have been sympathetic to the school's argument some comfort. So they can hear those answers and say, okay, I understand your theory does not sweep in everyone.
So a lot of what the school is trying to do is rely on this idea, this Latin phrase de minimis, which just means, I shouldn't have said this just means because I don't know exactly what it means. That's the literal translation, but what it means is things that are just a little bit don't count. And so he kept saying, if the teacher just does a little bit of religious function, well, that's not going to count. If the janitor does a little bit, that's not going to count, because there were worries by some members of the court, I think, fairly broadly across the ideological spectrum, not only about sweeping in too many people, but also about the prospect of schools or other religious employers kind of manipulating job duties in order to maximize the scope of the immunity. On the other hand, the teacher's lawyer also got some similarly tough questions because a lot of their focus has been on, look, don't focus simply on function. You also have to look at these other factors that the Supreme Court had considered in this prior case with Tabor that we talked about last time. And some of those factors include, does the person have a religious title? Are they called a minister or something like that? Do they have religious training? And there are quite a number of questions from the justices concerned about, well, fine, maybe that works fine in this case where you have a very established religion with a history of using titles and having specific training, but what does that do for, minority religions that may not have those kinds of titles or that kind of hierarchy and structure? There was a theme that was returned to both by some of the justices and by the school's lawyer that we need to have a rule here that isn't going to provide protection for religious freedom only to mainstream religious institutions.
Exactly, and there were a few times where the question was put, what about the other factors, and are they determinative? In other words, do you have to satisfy any one factor? And the employee's position pretty much across the board was no. There's no one factor that we think is necessary to satisfy, but you need to take them all into account. And there are a few factors that they wanted to elevate more than the schools were doing. For example, do you have to be a member of the religion to be considered, for purposes of this constitutional exception, a minister of that religion? So in other words, can a Jewish teacher be a Catholic minister for these purposes? And both sides were actually pressed on this question. I thought it was an interesting one. This is one of the issues that I think the teachers have seized on to say, it can't possibly be the case that you can be a member of another faith and then still be a minister of a different faith. Now, when pushed, they said, no, we're not saying this is a black and white on-off switch rule. We're not saying that you're automatically not a minister if you are not a member of that faith. But they said it's something that should be seriously considered. It's something that should weigh into the analysis. And same with the titles. They wanted to make that an important issue, but they didn't say it was an absolute yes or no.
And again, the response was from the other side that, look, that kind of rule risks prejudicing minority religions and smaller schools because, a smaller school may not be able to find in its community enough members of its faith to fill all its teaching roles, and will have to, choose somebody else. So, a Catholic church might hire a Lutheran, a practicing Lutheran to come and teach in their school. And is it fair to say that school has greater liability under the civil rights laws than a school in a big city where it's easier to fill those positions with members of the faith? So we have a question. Somebody has asked, to what extent is a religious organization allowed to fire a non-minister for a religious reason? And this is an interesting question. It actually came up in a question from Justice Breyer and some suggestions from the school's attorney. He was making the point that This ministerial exception is not the only protection for religious schools and religious entities from discrimination claims. For example, Title VII, which is the federal employment discrimination law, has an exception that says religious organizations can discriminate on the basis of religion to the extent of requiring somebody to be a member of their religion in order to work there. And in addition, Jeff Fisher, who was the attorney arguing for the teachers, pointed out that a school could raise an as-applied, which means an as-applied challenge, which means, as applied to this particular case, that the statute is unconstitutional because it interferes with the school's free exercise of religion, and suggested that most of the time when somebody at the school is being fired for reasons rooted in religion, they would have a pretty good argument that they would be protected by the free exercise clause. Is that consistent with your understanding, Dan?
So that was an interesting approach. And again, this falls into the category of helpful things to say to the Supreme Court to give them comfort that your position is not as extreme as your opponents might want to paint it. I will say on that question, the question of how much leeway does a religious organization have in hiring and firing employees who are not ministers? That is something of an open question. There is a fair amount of dispute right now. And I think the lower courts actually, for the most part, have gone the other way in saying that, yes, the civil rights statutes and the one that you just mentioned, Title VII, which covers employment discrimination, there is an exception for the hiring and firing by religious organizations of co-religionists. That is to say, people who are members of their own faith. So even if the person's not a minister, a religious organization can say the janitor has to be a member of our faith, even if we concede that they're not a minister. What is less clear is whether you can hire and fire, more importantly, someone for a reason that would be discriminatory on some other basis, so not religion. So can you discriminate on the basis, for example, of race, as long as you have a religious reason for doing so? And I think the lower courts generally have said no to that question. Although during the Supreme Court argument, the attorney for the employees told the Supreme Court that it probably was the case that a religious organization could do that, could discriminate on other bases, as long as they had a religious reason. Again, I don't think the lower courts are generally in agreement on that point. So it was an interesting approach, but overall, the idea here was to tell the Supreme Court, if you're an advocate for the employees, don't worry, if you rule for us, there's still a lot of protection for religious organizations.
And as Dan mentioned, this is actually a very common strategy, both in briefing and an oral argument in the Supreme Court. If you think that you're going to have a hard time convincing 5 justices to vote for your client, what you often want to do is develop a reason or a rule that is just broad enough for your client to win and nobody else, because, or vast groups of other people you're willing to let go, or at least potentially let go, because if you make a very broad claim to the Supreme Court, if you say that almost nobody is a minister, it's very unlikely you're going to win the case. And it can lead to this odd position where, a civil rights lawyer who's up there representing clients on a civil rights claim is effectively saying, in the next case, maybe the civil rights protections won't be as broad, but he's got to do that. He's up there representing his client. His only obligation is to that client. He can't go up there and represent the interests of other people, even if he thinks that's the better answer, because that's not his job.
And another area where I think something similar came up was one of the first questions in the argument, which was essentially, it was a question to the schools. The question is, do you believe that someone who is declared to be a role model or someone who is supposed to be personifying your faith, does that count enough? So is that all you need? So in other words, can you say, well, this person is meant to personify, in this case, the Catholic faith, and they're supposed to be Catholic role models, and therefore, simply by virtue of that, they are ministers. And it appeared that there was more of a suggestion in their briefs, and here's a distinction between briefs and oral argument, that this argument was embraced a little more by the schools. They said, yeah, one of the important things that these teachers did was they acted as role models. And that, they didn't quite say that alone is enough, but there was a suggestion that if they were employees that personified the faith, that were meant to demonstrate the religion in all of their daily activities to these students, then that would go a long way toward classifying them as ministers. But at the argument, the short answer was no, that's not enough. The schools themselves said that's not enough. And I thought that was if not necessarily a surprise, and a notable response, because it was a little bit pulling back. And again, that fits in the same theme that we've been talking about, which is you want to make your position seem not particularly extreme. You also want to cast it as being fully consistent with what the Supreme Court has done before. Now, there's only one case prior to this one, Hosanna Tabor, about the ministerial exception. So a lot of the argument focused on the fact that what we are arguing, and both sides said this, what we are arguing is exactly what you said the last time.
And it's another thing that came up. Well, let me say two things about that. One is, I suspect in the brief, the schools intentionally were sort of vague about what their position was with respect to whether it's enough that this school requires you as a teacher to model religious values. I suspect that they want to be able to argue in the next case that that is enough, but were thought that they didn't actually have to win that battle in this case, and that position might turn people off, and so they were just sort of ambiguous about it in their briefing. It's very easy to do that in your briefing and hard to get away with it at oral argument, and it's precisely because they were ambiguous about it that the Chief Justice asked that as the first question. The other thing I was wanting to point to, and so we don't lose sight of this, is I thought another theme throughout the questioning was how are we going to apply this test without enmeshing the courts in religious disputes? And that came up on both sides. So the schools got questions, which isn't uncommon, from some of the most conservative members of the court, from Justice Thomas and Justice Gorsuch, essentially suggesting that the schools had given too much ground to the middle, and that they thought that any test that allowed courts to be the judge of what's an important religious function was a big problem, because it requires courts to either get enmeshed in this debate about who's right about how important how important of a religious function it is, or would otherwise, and this is less a problem for Justice Thomas and Justice Gorsuch, but for folks on the other side, if you just defer to the school and say anybody you say a minister is a minister, well, then you've written a blank check for discrimination and are potentially encompassing a lot of people that you wouldn't think ought to be encompassed. And so that was a struggle I thought was recurring throughout the argument.
Yeah, that's exactly right. This question of, does your position, whichever side, require us to entangle ourselves, and us being not just the Supreme Court, but any court that hears a dispute like this in the future? Are we getting too involved? And the solution that Justice Thomas suggested in his earlier concurring opinion in the first case, Hosanna Tabor, 8 years ago, which seemed to be a position shared by Justice Gorsuch, is, as Kevin said, we shouldn't be second guessing religious organizations. It is not the place of a court to get involved. If there's a sincere assessment by the religious group, this person is a minister or this position is a minister, that's all courts should be asking. And I'm not sure I heard from any of the other justices support for that idea, because as Kevin mentioned, the danger there is then there's too much deference. Well, what if a religious organization says, we think the janitor is a minister, we sincerely believe that, we believe everyone is, then does that mean that none of these employees get the protections of the civil rights laws?
So Dan, who do you view as sort of the key justices in this case? We talk often of swing justices, and you sometimes think that you know who they are and they're always the same, but in reality it can change from case to case. Who do you view as being the key people to watch during the argument?
Yeah, I think for the most part, well, first of all, I want to make clear, and justices certainly have said this in various contexts, that you shouldn't read too much into the questions, right? So some justices will ask hard questions of the side that they ultimately plan to support because they themselves want to test their own views. So I don't want to give too much emphasis or too much weight to the questions that were asked. But it seemed to me that the justices were generally lining up the way they typically do. I hesitate to use the terms liberal and conservative, but there were similar alignments that seemed to be playing out in this case. So the question is, who's in the middle? Who might go either way? And I'm not sure. I mean, I imagine a lot of listeners, including the litigants, were looking to see what the Chief Justice thought, what Justice Kavanaugh thought. Like I said, I didn't get the sense that there were 5 votes or maybe even more than 2 for what I view as sort of the most extreme view of the rights of the religious organizations, which is to say absolute deference to what they sincerely believe. But beyond that, it was unclear. But I think a couple of those justices were the ones to watch, the ones I mentioned. I don't know.
I would just add one more, which is Elena Kagan, because she joined Justice Alito's separate concurrence in Hosanna Tabor, which laid out the foundation for the school's argument here that you really need to focus not so much on labels and titles, because that can be discriminatory against minority religions, but instead be really focused on their religious function. So I don't see how the teachers could win this case without getting Elena Kagan's vote. And so I think it was important to be listening to her question. She asked questions that were skeptical about this idea of, being, somebody who is not a co-religionist is nonetheless a minister. And she asked a lot of questions. She asked, in one turn that she asked like 5 or 6 hypothetical questions in a row, trying to figure out who's in and who's out, and how do you figure that out? And so it's not clear to me from the questioning where she's going to come out at the end of the day. I would be surprised, as Dan would be, if she signed on to an opinion that says you always defer to the schools. But it would also not surprise me if there was some effort to find some middle ground that resulted in Justice Kagan voting with the conservatives to perhaps rule in favor of the schools in this case, but to limit the scope of the rule in order to make sure that people like, the math teacher who leads a prayer once a day, or nurses in a religiously affiliated hospital aren't covered.
Yeah. And we got a question that feeds into exactly what Kevin was talking about. The question is, what do we make of this new format, under which the Supreme Court has held oral arguments by telephone? And as I think many people know, but in case you don't, the way it works now, which is different from live arguments, among other things, is that each justice gets the opportunity to ask a question in order of seniority, with the Chief Justice going first. And the Chief has been pretty effective at watching the clock, although the arguments have gone longer than is typical. But what that means is that if there's any particular justice that has a strong interest in this case, unlike a live argument, they will not have the opportunity for a back and forth 3 or 4 times. They have their allotted time. And so they have to get in their questions. And if they have a series of questions that build upon one another, that's a lot harder to do in their limited time. So Justice Kagan, recognizing that, she started out her questions saying, I just want a yes or no. I have a series of quick hypotheticals, and please just give me a yes or no. Would this person count as a minister? And she was prepared for that, obviously, and I think it worked. She got through all of the questions, but sometimes it's tough for the justices to make their follow-up points in this format.
Another consequence of the format is it seems like the justices are kind of pre-writing their questions ahead of time. And you saw a little bit of this in the argument. Sometimes, a question that they intended to ask will have just been asked by another justice, and they either end up asking the same question, which isn't all that helpful, or having to scramble to think of some other question. I mean, there are pluses and minuses to this new format. One of the pluses is that Justice Thomas, as has been remarked in some of the press, has been asking questions, which he almost never does at actual oral arguments, I think because he thinks that those arguments don't give the advocates a fair chance to answer their questions before somebody else jumps in. And he doesn't really like the hurly-burly of the oral argument format when they're all there together. But he's been asking some questions. He's been asking good questions too. And I think the advocates are probably happy to get the questions because, what you're up there not just to make a bunch of points, you're up there trying to convince the justices. And if they will tell you through their questions, as they often do, what it is about your position that is bothering them, you have a chance, a last chance to try to persuade them that you're right, or that there's something that they've overlooked, or that there's another solution to the problem that they've identified, which lets them vote for you in this case, but solve those other problems in another one. And I think you saw a lot of that going on in this argument.
Yeah, one of the other common themes, there were a lot of things that both sides were saying. Both sides were saying that their view was more consistent with the earlier case. Both sides were saying that their test was easier to administer and that it avoided entanglement problems. Neither side treated the two cases, because remember, these are two separate cases that have been consolidated. Neither side treated the two cases differently, that is to say, the facts of the two cases. So everyone at the argument, justices and litigants, seem to be assuming that whatever the decision is, it's going to be the same for both cases. Just wanted to flag one other thing, which is a feature of this argument and many others. Another thing that both sides were talking about was what they described sometimes as a parade of horribles. If you accept the other side's position, here are all of the bad things that are going to happen. And this is also another metaphor used is opening the floodgates. If you open the floodgates, this is a mess of problems that we will see in the future. And these are terms that we actually heard yesterday in a completely unrelated set of arguments over the president's financial records. Same question, what about the parade of horribles? If you're right, doesn't that mean the sky is going to fall tomorrow? And it's just interesting to see that kind of theme recur, not only in this argument, but across the board in many Supreme Court arguments.
So we only have a couple minutes left. So maybe we can use them to give folks your predictions and my predictions about how this is going to come out. Dan, are you going to hazard a guess?
I think it's going to be tough for the employees to get 5 votes. So I think it's a tough road for them. To me, what is, I think, more up in the air, and of course the outcome's up in the air too, because as I said, you can't predict with any certainty, but what sort of test is going to emerge and what will be the lineup with the justices? How many opinions are we going to see? I mean, typically the justices like to avoid multiple opinions. They like to have one out there that says, this is the rule. And we had that in the prior decision in this area, Hosanna Tabor. It was a unanimous decision, in fact. And the question is the court going to be willing to say more than what they said there? They were very careful not to lay down any hard and fast rules. They said, we're going to consider a bunch of factors. We're not going to say one weighs more heavily than the other. And I am skeptical that there is going to be consensus to say all that much more than that, but I'm curious to see. What do you think, Kevin?
Yeah, I tend to agree with that. It comes down a little bit to the question of why did they take this case? So one possibility is they took the case because they wanted to elaborate on the test and give it some more meat, or because they wanted to maybe go in the direction that the school is pushing them in towards, saying, yeah, there's these 4 factors, but the most important one is function, and they saw this as an opportunity to provide that guidance. Another possibility is they thought that the Court of Appeals, which here was the Ninth Circuit, which is out covering most of the West Coast and has a reputation for sometimes resisting Supreme Court precedent that the judges out there disagree with, and they have a reputation for being more liberal. So it's possible that the court took this case because they thought the Ninth Circuit was simply sort of thumbing its nose at Hosanna Tabor. And if that's why they took it, I think it's much more likely to end up as Dan suggests, with them saying, look, we've already told you what the test is. We're going to apply it here, or maybe not even apply it. Tell the Ninth Circuit that you misconstrued it. Go back and try again. But not do much in the ways of providing further elaboration. I'd be surprised if they would say, look, religious function is the most important thing. I'd be surprised if they accepted the proposition that you simply have to accept the school's decision about who counts as a minister. And if those things are off the table for a majority of the justices, it's not clear how much more they can say other than just saying, whether these 2 teachers win or lose, which will provide some guidance for future cases, but will not result in a huge dramatic shift in the law. Well, thank you for joining us. We've run out of time. We appreciate your listening to this discussion and hope you found it helpful. This video will be eventually posted on SCOTUS blog, where you can find links to our prior pre-argument discussion and links to the transcript or the oral argument, or the audio recording of the oral argument. And you can even find the briefs there on SCOTUS blog if you want to take a deeper dive into the case.